And thank you for joining us today. I'm Carol Jenkins. The program is Black America, and we're talking about our criminal justice system, particularly as it applies to the death penalty. With us today, Christina Swarns, Director of Litigation for the NAACP Legal Defense and Educational Fund. She is lead counsel in the Texas versus Dwayne Buck case, a Texas death sentence case about a man sentenced to death because he's Black. And we're going to talk about just that clear an instance of the reason that you think that you could go to the Supreme Court and get them to reverse his sentence.
Thank you so much for having me on here this morning, Carol. It's a pleasure to be here to talk to you about Mr. Buck's case. You know, Dwayne Buck is an African-American man who is on death row in Texas today. Astonishingly, in 1997, when he was tried and prosecuted for murder, his own lawyers introduced expert testimony that said that he was more likely to be dangerous in the future because he's Black. In Texas, a finding of future dangerousness is a key prerequisite for a death sentence. So essentially, his own lawyers presented the evidence that ensured that he would be sentenced to death, and that evidence was the fact that he was Black. It's astonishing in 1997 that that kind of evidence was presented without objection.
So this is a clear cut. This is racial discrimination. You know, it's not allowed. The man should be free, even though he did. I guess it's a question of not free, but that because he confessed to the crime, but that he should not be killed because of it. He shouldn't go to the execution.
That's right. That's right. I mean, there's no question. He does not dispute his guilt in the shooting deaths of two people. The question in front of the courts now is what the punishment for that crime should be and whether the punishment that he has received is fair. And in our view, no sentence, no person should be condemned to death based on testimony that says that they should be executed because of their race.
Now, I was looking at the numbers. This is a Texas case, and if you go down the line and you look at all the states, there are some who've executed 2 people, 20, maybe 50. Texas is almost 600 people that they have killed, and it seems summarily.
It is astonishing. You know, Texas is, really off the charts for the death penalty in this country. It has led, in death sentences and executions for years. It's hard to explain, and I should also add that Dwayne Buck was sentenced in Harris County, that's Houston, and Houston itself has sent more people to the death penalty and executed more people, sort of second only to Texas, I should say. So if you do a list and you just did sheer numbers of people who've been condemned and executed, the list would be Texas, and then after Texas would be Harris County, just in terms of the sheer volume of people. And on top of that, throughout history, the people that have been executed and condemned in Texas have been overwhelmingly Black. That is without any time, without exception in history.
Well, anywhere, right, in the country, right? Most of the people being killed or sent to their death.
That's right. That's right. But even recently, in the last dozen or so years, the only people sentenced to death in Harris County have been Black or Latino. I mean, it's a remarkable statistic.
So where's the big investigation? What do you do about something is wrong?
Something is very wrong. Something is very wrong. I guess it's hard to say. We have been working in Texas, the Legal Defense Fund, for years sort of around these issues and exposing and bringing to light, the discrimination that we think has corrupted and really rendered the death penalty in Texas fundamentally unfair. This is our second case that we worked on. The first one was for a Latino gentleman, a Mexican American, who was sentenced to death after all Black and Latino people were excluded from his jury. That conviction was set aside because of the discrimination in that case. We're now working on Mr. Buck's case, and with both of these cases, we sort of, like our conversation today, use them to expose the injustice of the death penalty system. We talk about it and we bring to light sort of the statistics and demonstrate how these cases are emblematic of the problems in the system.
Now, the LDF doesn't believe in that there should be any death penalty whatsoever anywhere,
That's
state or federal.
That's right.
Not in existence at all in our country.
That's right.
Explain. There are many who disagree with you.
Many. I think what we have concluded is, first and foremost, the death penalty system is fundamentally flawed and fundamentally human, sort of. So in its fallibility, it is, the fallibility that is built into the system is a product of human fallibility. And one of the things that we know that sort of runs through sort of the history and the fabric of our country is sort of a predisposition to link race and criminality. That is from slavery, from Reconstruction, from the laws that came out of sort of the history of our country. And unfortunately, the studies over and over and over again show that plays out in death sentencing in our country, right? African Americans are, when you compare them to similarly situated white offenders, are far more likely to be capitally prosecuted and condemned and executed. And so for us, when you see race playing such a dispositive role in a purportedly neutral, and it really has to be, right, a system that really we rely on to make fair and equitable judgments about, crime and sentences, if it is corrupted by race in that way, then it can't be constitutional. And so our position is that there should just be no death penalty because it cannot be administered fairly and without race playing a role.
So just yesterday, the Obama administration announced that it was seeking the death penalty in the Charleston case. You disagree with the president?
We do.
But that was so horrific. That was 9 people murdered in a church. There's no reason, no crime that would that you would say would fit the death penalty.
None. And it is, the Charleston 9 situation is, it's horrendous. There's no nice thing to say about it. And there's there's nothing at this moment that I could say that would be nice about those who, Mr. Roof or whoever committed that crime. But that doesn't change the fact that, in our view, the death penalty system is broken. It's not just race, right? We are structurally underfunding lawyers who handle these cases, right? We do not provide adequate training to the lawyers that are handling these cases. They're pitted against prosecutors who have the resources of the federal government, who have the resources of all of law enforcement. And so there are deep inequities in terms of the way these cases are litigated. So it's not just race that makes the death penalty system unfair. And so there are other issues that we think would play equally into the Dylann Roof case that would make it inappropriate for a death sentence in his case. And I would just also say, I don't think that the way to balance, to counteract the problem of too many black people being sentenced to death is to execute white people. I don't think that, that's the ratchet. That's not a remedy. No, I'm not seeking to even the score that way, right? I think the system is broken. If it doesn't work, it doesn't work, is generally the way we look at it.
Well, a lot of the news coverage recently has been about the methods of executions. And one drug company has said, I guess it's Pfizer, that said that it will no longer provide its chemicals to end the lives of people. Does that help your case at all, or against the death penalty? That people have watched the barbaric way in which people have died, and they think, "Oh, now I get it, and it shouldn't be done."
I think that there has been a perception that lethal injection is this sort of sanitary and clean and peaceful way to execute people, which made, Americans more comfortable with the death penalty, especially coming as it did on the heels of electrocutions where, which turned out very badly. Yes, exactly.
Right.
Electrocutions and gas chambers, which were just visibly grisly.
Right.
And so the transition to lethal injection was sort of for the viewer as well as for purportedly the condemned. The reality, however, is that studies show, and anesthesiologists and experts have demonstrated, that the folks who are administering the lethal injections are rarely doctors. They're not doing it in a way that accomplishes the goal as it was articulated. People are, literally tortured to death in the lethal injection process. And we saw that a year or so ago with a gentleman in Oklahoma, who had this tragically botched execution. And so I think what has happened is that the pharmaceutical, and I'm not involved in sort of that, but it appears that the pharmaceutical companies have, sort of, as we all have watched this process and have concluded, that they've sort of gone back to their roots and said, our work is about life saving. It is about pain amelioration. It is not about, ending people's lives. And so they just don't want to be in the business of executions. At least that's what they're saying right now.
Right. Well, there are so many who disagree because there is the need for vengeance. And just having someone sit for the rest of their lives in a cell doesn't feel appropriate. So it comes to that spiritual, philosophical question
That's
of
right.
should we want, for
Right.
instance, in the case of terrorism,
That's
should
right.
we want
That's right.
that a more severe punishment?
Right.
How do you handle the punishment? Is that a reworking of our sense of things?
It's a great question, right? What is enough? Like, what is a punishment? Is there enough punishment are there, crimes that are so bad that, there is no punishment that is enough? I would say, I would look to other countries which offer interesting alternative viewpoints, right? If you look at Europe, there was was it Norway, right? This mass killing, right?
Yes.
And sort of there are other countries that are handling really severe crimes
And
in
he's
very
is he about to
different
be
ways.
released? or-
I don't follow it, but I know, like the death penalty
Yes.
was never an option, right? Life
Exact-
imprisonment was never an option. It's just a different viewpoint.
Even life imprisonment, right?
No, it was
So-
not an option in
Right.
those cases. I think it's a different viewpoint. I also think, I often say, like, I wish people could see and understand how my clients came to the point of committing the crimes that they did. Because almost without exception, these are the people who, and I don't say this to say it excuses the behavior, but it's at least to understand, right? People don't wake up usually in the morning and say, I'm going to butcher 15 people, right?
Right.
That doesn't happen, right? These are people who have deep mental illness, who have, gross undereducation, who have drug and alcohol problems. If you're getting a confluence of events, which frankly, if we diverted our time and focus and money,
Right.
to addressing these problems, we would see, I think, an amelioration in the kind of crimes that winds people up on death row and in prison, And so it's just about where, we want to allocate our funding and our time and our attention. But I think, in my view, if we put it at the front end, you would see the reward sort of at the back end, and you wouldn't really need the death penalty or life in prison as much.
So one of the famous cases that you were involved in, lots of news coverage, was the Mumia Abu Jamal case. Tell us about that. You succeeded in having his life spared.
That's right. So Mumia is a African-American man who was sentenced to death he was convicted of a murder in Philadelphia of a white police officer in 1981. He was sentenced to death in 1982, and he remained on death row for, 30 years or so, until the death sentence was set aside based on a legal challenge my office, myself, and my colleagues brought to the Supreme
Don't be modest.
that I
Yes,
brought,
that you
we
brought,
litigated
right.
to the Supreme Court. It was a deeply controversial case. It remains a deeply controversial case in Philadelphia and elsewhere. But at the end of the day, after it became clear that the Constitution was violated in his case, and in this case it was again at the sentencing process, it wasn't a guilt decision in that case, the Philadelphia District Attorney's Office decided not to seek another death sentence, and he was resentenced to life. Questions about his guilt persist. There's real reason, and we have always said that there's real reason to question, his guilt in this case. If you look at the factors that are traditionally in wrongful conviction cases, they're all in Mr. Abu Jamal's case. This is a situation where you have a witness identification testimony. We know that is often found to be false, right? There are statements attributed to Mr. Abu Jamal, at the time, which are in dispute. There's just a lot of factors that are, if you look at sort of the exoneration cases, that also apply to Mr. Abu Jamal's case. The forensics in this case, there's a lot of questions about the bullets and the police collection of evidence at the time of the crime. So there's a lot of unanswered questions about his guilt.
Yeah. So you and I were talking earlier about the tally in terms of the number of people you have saved, and it's up to at least 7. It may be more than that, but that you've spared the lives of 7. All men?
All men.
All men on death row. What the very first one? What was your reaction to
That's a great question.
to that?
So the first one that comes to mind, and I'd have to think, and I'm not sure it's the first one, but I had a client in Pennsylvania His name was Nicholas Yaris, and he was exonerated. That was a full, complete DNA exoneration, which was, it was amazing. It was unbelievable, even for us as we were going through the process, as the evidence was coming back, and I can actually remember the day I was traveling, getting on an airplane, and I got a phone call on my cell saying, with the lab results, saying that he had been cleared. And I can remember saying, I was like, what? It was astonishing, And I can also remember the day after he was released. I had left Pennsylvania and come to New York to join the Legal Defense Fund. So I wasn't there for his walk out of prison. And he called me on my cell phone, in the car on his way home. And it was just, I was like, you're calling me on my cell phone. You're on your way home to pay. It was amazing.
Right, right. What an incredible, and of course, the advancement of DNA testing has also
changed things.
Has changed
so
it
much,
and
so
brought
much.
a lot of people to your side of thinking.
Yeah, right. It really has adjusted
because there's so many mistakes.
That's right. That's right.
And that
and
was
it's science, right? So we can say, right, this is science now.
So how does Christina Swarns get to this point of going before the Supreme Court, saving men's and women's lives? How did all of this happen? Place yourself in Black America for us. Where were you born, and what were your earliest influences that brought you to the Supreme Court?
Sure. So I was born in Queens, New York, but I was raised in Staten Island, New York. But my early influences, like many of us, was my family, the people that I was surrounded by. And in my household, I was surrounded by a bunch of folks who were deeply immersed in Black history and culture and politics. It was the way we lived. My uncles who were community organizers, and it was just, the conversation all the time in our house. It's Black history. We grew up with the names Thurgood Marshall and these extraordinary.
And now you have his job.
And now I have. I don't have his job, right? But I have a job, in his law
in the organization that he started.
Yes,
right.
It's
so
amazing.
So Thurgood Marshall, who later joined the Supreme Court himself, the first Black person to be on that prestigious court, founded the NAACP.
Yes, he founded the Legal Defense Fund. That's right.
Right.
That's right. So I mean, it's for me, it is I try not to think about it too much because it's
you got a little nervous when I said you have his job.
It's a big,
sitting on the Supreme Court next, so that you were told about him then as
absolutely.
child.
This was my ideal. I want to be Thurgood. There's no question. I want to be Thurgood Marshall. Absolutely.
And so here you are.
And so here I am, and I try my best every day to make him proud. And we often, talk about Uncle Thurgood in the office. So I'm like, I hope Uncle Thurgood is proud.
Do you refer to him as Uncle?
Yes, absolutely. We refer to him as Uncle Thurgood, and so I hope Uncle Thurgood is proud of the fight I'm fighting.
So let's talk about some of the other cases, other than criminal justice cases. It was, of course, the Brown case that Thurgood Marshall himself took to the Supreme Court. And what is your impression about it? Was intended to desegregate schools across this country. What's your assessment of how effective it was, that particular judgment?
So there can be no doubt that the Brown versus Board of Education decision was transformational. It was groundbreaking, right? This was the decision that said, ultimately, that the United States could not condone legal segregation. It started out in schools, but it couldn't be cabined to schools, so it continued into public accommodations, et cetera, et cetera, et cetera. So it was groundbreaking. It was enormous, right? The enormity of that decision is, it's unparalleled, right, in American history. As you know, the devil is in the details, right? The Supreme Court pronounces that the schools have to be desegregated. But there were years and years, in the immediate wake of struggles to enforce that dictate. And I have to tell you that we at the Legal Defense Fund still carry a docket of about 100 desegregation cases that were filed in the wake of Brown in the face of Southern, recalcitrance to the enforcement of the Brown decision. And so we are still, to this day, pushing and enforcing consent decrees to ensure that schools in the Deep South, are equally available and functioning appropriately for Black and white students, that there is real meaningful diversity, that there's real meaningful, facilities, equality. I mean, we're still actually litigating over some of the original Brown issues. I mean, it's amazing.
So does it make you think, as many people say, oh, it's one thing to have the law, but it's another thing to change the psyche of the American people in so many ways? I mean,
You have to do both. I think there's no question. You know, I think that would be, you know, one of the opportunities that we have now, sort of with the internet and with sort of the 24-hour news cycle and all of the vehicles for communication that are available to us now. We have an opportunity to take our message outside of sort of the four corners of the courtroom, and make sure it's reaching people in a way that I think it was harder to do before, right? So not only for us in our work, not only do we litigate in courtrooms and write, you know, really, I think, beautiful briefs, you know, we also have community organizers who are out in the communities that we serve, you know, making sure that folks know about our work. We have, you know, communications apparatus, so we make sure that, you know, our information is getting out to the public. And we're now just launching a Thurgood Marshall Institute at LDF, which will be a policy hub inside of LDF, so we can even do deeper, more thought-provoking, comprehensive analyses of the issues of the day.
yeah, and certainly the new voter suppression laws that are, well, that's not exactly an artful way of phrasing it, but looking at the long, long lines in so many of the polling places.
That's right.
Where apparently what the Supreme Court took away was the pre-clearance.
Yep.
In other words, you would have to go and get permission to change the laws before you did. And so now states can just actually willy-nilly do whatever they want.
That's right. That's right. So there was a law under the Voting Rights Act that said that states and jurisdictions with a long history, right, of intentional discrimination against African Americans, you know, lost their right essentially to make voting decisions without the approval of the Justice Department and ultimately the federal court.
The LDF was very instrumental in getting all of that done.
Absolutely. And we've been involved in the voting rights fight since our inception.
So what do you think about this turn back in a way?
You know, it's remarkable. You know, we have been actively involved in the voter ID struggle. We are litigating a case in Texas, the challenge to the Texas voter ID law.
Again, Texas, how surprising.
We're back in Texas. We spend a lot of time in Texas, we do.
Right.
You know, I think one of the more remarkable, and there are a lot of remarkable things about, I think, the Texas voter ID law, but I think I'll just pick two. You know, people often say, oh, well, you know, how hard is it, right? It's not that hard. How is it such a big deal to be asked to show your ID and to have proper ID?
Right.
You know, and we have said, you know, it's different for African Americans. And one of the ways it's different is, you know, we presented the testimony of an older African American woman who was born under segregation. She was born at home, right? At a time where in Louisiana, the only hospital near her was an all-white hospital, so she couldn't go there. So when she was born at home, there was a whole, you know, separate process of obtaining a birth certificate. And so when she went through that process, because of the way things were at that time, they weren't super careful about getting her name right? Getting it spelled right, getting it accurate. So her birth certificate is inaccurate, you know, and if you say, and all of the sort of documents required under the Texas voter ID law require the birth certificate. And so it has become an impossibility for this woman because of the segregation, right? The racial discrimination in our country. It's an enormous burden on her to go through the process of getting one of the requisite IDs. So that's just entrenched in the history of our country. The second issue I would point to is that, you know, Texas has always said, you know, we need this law to prevent voter fraud, right? We want to make sure that people are not, you know, cheating and presenting themselves as others at the ballot. Now, there's a lot of things wrong with that, not the least of which being that maybe 2 voter fraud cases have ever been prosecuted.
So few.
Exactly, there's just none.
Right.
But the other thing that's interesting is that throughout history in Texas, the most discriminatory voter laws have always been justified by voter fraud. Poll taxes, literacy tests, all of the big, you know, historical vehicles for preventing African American access to the ballot, all of them. The explanation, if you look back through history, voter fraud. It's the same thing, you know, it's just not any different. You know, you see today, you know, hundreds of thousands of registered Texans are not going to have access to the ballot because of this law.
Right, and I'm sure as you're looking at all of the police, black men and women and girls and boys interaction, you must have this sense of, how do we get out of this? It's endless litigation, endless, is that the way you view it in terms of the future of all of the people who are incarcerated and, unfairly?
Yeah, it can be overwhelming at times, I mean, the one view of it is that it doesn't stop, right? That the problems continued. I guess the view I sort of cling to is how exciting is it that this generation behind me is so excited and so, involved and so awake and aware and ready to speak out about these issues. That was not my generation, and
That's
so
true.
it's
That's
fantastic to me.
Right.
To see this electricity around these issues. So I think that gives me hope that my daughter's generation, will be very different and things will be different for her.
Right, right. So we always ask our guests to finish the sentence, the power, the strength of Black America lies in, and what do you think? Are you illegal? As a lawyer, you would say the law.
No. Oh gosh. The power, let's say it again.
The power, the strength of Black America lies in.
Oh, that's history. I think it's in the history. We are a people who throughout history have survived enormous struggles. Nothing has kept us down and nothing will keep us down. We will always achieve and do amazing things.
And even sitting there in your office, looking at the cases that you have to present, you're optimistic about the...
Absolutely. Absolutely. I wouldn't be able to do this if I didn't have hope that things were going to, it was going to work. We were going to do good things. And I think we are. I'm confident we are.
Well, thank you so much for being with us today, and thank you for your work.
Thank you.
And it's been a pleasure talking with you today about the death penalty, about voting, all of those essential things that we need. Keep working.
Thank you.
And thanks to you two for joining us today. We will see you the next time. I'm Carol Jenkins. The program is Black America.
Legally unconstitutional. No one can be sentenced to death based on their race.